Have you ever, looked at a medical bill, just stared at this endless list of line items, and felt a wave of complete confusion?
Oh, yeah. Like, what is this miscellaneous charge for $400?
Exactly. Or, maybe you've looked at your car insurance premiums and watched them just creep up year after year, even if you haven't had any accidents, and you're wondering, what exactly am I actually paying for here?
Right.
Well, today, we are looking at the invisible mechanics of insurance fraud. We're going to explore why catching this kind of fraud is sometimes, it's harder than finding a needle in a haystack.
Especially when the fraudsters happen to, own the haystack.
Right, the
Yeah.
haystack, the farm, and, the needle factory itself.
Yeah. So for this deep dive, we are pulling from an October 2024 decision from the United States Court of Appeals for the Second Circuit.
Okay.
The case is State Farm Mutual v. Borough, and it details this just staggering multi-million-dollar alleged medical and insurance fraud operation.
And the sheer scale of the alleged grift is totally fascinating. But the real story here is the incredible legal gymnastics required to actually stop it.
It really is.
We're looking at how a group of doctors and businessmen allegedly just hacked New York's no-fault insurance system. And we'll get into the legal paradox of how thousands of seemingly legitimate tiny lawsuits can actually be weaponized to run a massive criminal enterprise.
Yeah, because when you think of organized crime, your mind naturally goes to elaborate bank heists or shady back alley deals.
Right. Definitely not arbitration filings.
Exactly. You don't picture a stack of paperwork in a chiropractor's waiting room. But to understand how this machinery operates, we really have to start with the environment it grew in. So New York has something called the Comprehensive Motor Vehicle Insurance Reparations Act.
Which is a mouthful.
Yeah, most people just know it as the No Fault Act.
The No Fault Act.
And the intention behind this system is actually incredibly practical. The goal is to ensure prompt, frictionless compensation for auto accident victims.
So if you get hurt, you get paid fast.
Basically. If you are injured in a crash in New York, the system provides coverage for your necessary health expenses up to $50,000 per person. And that happens regardless of who actually caused the crash.
Wow, 50 grand. Okay.
Yeah, it's designed to keep, a million minor fender bender cases out of backlogged courts and just get people the physical care they need right away.
Right. And mechanically, the way they made it frictionless is by having the patient assign these benefits directly to their healthcare provider.
Exactly.
You get into an accident, your neck hurts, you go to the clinic, the doctor treats you, and then the clinic bills the insurance company like State Farm directly.
Yep.
So the patient never has to act as the middleman handling the invoices, which honestly sounds like an incredibly efficient way to handle things.
I mean, it functions beautifully for legitimate claims, but whenever a system creates a massive guaranteed pool of money with expedited payout rules, it inadvertently creates a highly attractive target.
Yeah, of course.
We are talking about a $50,000 pot of money sitting over the head of every single patient who walks through the door.
Oh, wow.
So the logistical challenge for a fraudster is figuring out how to systematically and reliably drain that specific pot.
And that brings us to the blueprint of what is often called a medical mill. The source documents lay out the allegations of how this specific enterprise functioned, and it starts with 4 locations scattered across Brooklyn, Queens, and the Bronx.
Right, the gatekeeper clinics.
Yeah. They operated under the umbrella of a practice called Metro Pain, which later morphed into Tri-Borough Medical. And the function of these gatekeeper clinics is it's completely counterintuitive. I mean, you would assume an initial exam after a car crash is meant to figure out what's wrong with you.
Right, but according to the court documents, diagnosis was allegedly not the goal here at all.
Not the goal.
No, State Farm claims these initial exams were merely the first step on a predetermined conveyor belt.
Like an assembly line.
Exactly. The exams weren't tailored to find individual injuries. They were designed to justify a massive standardized treatment plan that applied to virtually everyone.
And the source gets very specific about this. It alleges that virtually every patient who walked in was prescribed the exact same combination of physical therapy, chiropractic care, and acupuncture.
Yeah, package deal.
And it didn't even stop there. Then came the referrals for unnecessary MRIs. They're handing out cervical collars, prescribing specialized pain management patches.
Literally just checking boxes.
Yeah. It seemingly did not matter if you survived a horrific rollover crash on the interstate or if you just got your bumper tapped at a red light. You got the combo meal.
And the sheer uniformity of the treatment plans is what actually flagged the system. I mean, the insurance company submitted hundreds of pages of charts to the court showing identical treatment protocols across the board.
Hundreds of pages. That's wild.
And follow-up reports would regularly just mandate the continuation of this allegedly unnecessary care. Plus, doctors at these gatekeeper clinics were routinely referring patients for pain management and orthopedic consultations.
Which means more money.
Exactly, because that inevitably led to invasive procedures involving anesthesia, which bill incredibly high.
It is mind-boggling to think about this at scale. Like, I mean, imagine taking your car to a mechanic for a standard oil change.
Okay.
But this particular mechanic has a predetermined protocol. So it doesn't matter what you ask them to do, they're going to replace the transmission, repaint all 4 doors, and put brand new tires on every single vehicle that rolls into the shop.
Every single one.
Right. And they never even run it by you because they just send this massive bill directly to the car manufacturer.
That mechanic analogy highlights the absurdity of the volume perfectly. But we also have to recognize the human cost here, too.
Right.
Because it is easy to look at this operation and think, well, the only victim is a giant faceless insurance company losing some profit margin. But the real victim is the patient lying on the table.
Wait, hold on. I'm getting stuck on something here.
What's that?
If the patient is getting thousands of dollars of free physical therapy and pain patches, how are they the victim? They're getting free stuff.
Because the care isn't actually free. Remember that $50,000 no-fault limit we just discussed?
Oh, right. The pot of money.
Exactly. Every single unnecessary acupuncture session, every unneeded MRI, every overpriced pain patch eats away at that patient's finite policy limit.
Oh, wow. I didn't even think of that.
Yeah, it diverts funds away from the legitimate medical care that the accident victim might genuinely need down the line. If a patient discovers they require, say, serious spinal surgery a year after the crash.
But their limit is already gone.
Yes.
Yeah.
Their $50,000 limit has been totally drained by a clinic running up the meter. That patient is left entirely exposed. They have absolutely no coverage left.
Man, that completely changes the stakes. They aren't just stealing from the insurer. They are literally burning through the patient's safety net.
Precisely.
So, okay, we understand how the money is being drained on the clinic floor, but orchestrating this requires a massive web of separate chiropractors, acupuncturists, and MRI centers.
A huge network.
How do you coordinate all of that without leaving a massive paper trail? I mean, we really have to follow the money into the back office here.
Well, the source introduces 3 key players who allegedly ran this entire operation. First, there's Dr. Leonid Shapiro, who is a licensed anesthesiologist and the purported owner of the medical clinics.
Okay, the medical face.
Right. Second is Reuven Alon, who is not a doctor. He's a businessman and a marketer. And third is Jan Moshe, another businessman and Alon's cousin, who happens to own multiple ambulatory surgery centers, or ASCs.
And the way these 3 allegedly operated is just a masterclass in disguised financial arrangements. State Farm's lawsuit alleges they were running a massive pay-to-play scheme.
Basically kickbacks for patient referrals.
Right. But obviously, you can't just write a check with the word bribe in the memo line. The auditors would catch it instantly. So they allegedly disguised the kickbacks as commercial rent.
Yeah, the discrepancies in the real estate leases here are fascinating. So the court documents detail a situation where a gatekeeper clinic pays around $8,500 a month to lease a building.
Okay.
Then the clinic subleases small portions of that space to independent specialists, like the chiropractors and acupuncturists. But the clinic collects about $9,500 a month in rent from those specialists.
Wait, they're collecting more in sublease rent than the cost of the entire building.
Yes. And the structure of that rent is the real tell here. State Farm alleges that many of these specialists were paying the exact same flat rate in rent, whether they treated patients at that location 5 days a week or literally just 1 day a month.
That makes no sense.
Oh, right. A flat, fixed lease looks perfectly boring and legitimate on a balance sheet. But the allegation is that this money isn't for physical square footage at all. It is a camouflaged kickback to compensate the gatekeeper clinic for feeding the specialist a guaranteed steady stream of patients.
And then there's something called the Beshert Network. This was a marketing company owned by Reuven Alon, but State Farm claims it basically functioned as a high-end referral ring.
A very expensive club.
Yeah, members of this network paid massive monthly dues. The documents cite up to $50,000 a month paid by Jan Moshe's surgery centers. And, I mean, for $50,000 a month, you aren't just buying billboard space.
No, you're buying exclusive patient access.
Exactly. Metropane, the gatekeeper clinic, allegedly sent their patients exclusively to Moshe's surgery centers for their procedures.
And this arrangement crashes directly into New York's licensing violations, which is a crucial structural component of the fraud. Under New York law, medical services corporations must be owned and operated by licensed professionals, like physicians.
Laypersons cannot own or control medical clinics.
Exactly. But the court documents allege that Jan Moshe, the businessman, was the one secretly pulling the strings behind all these entities.
And the mechanics of how he pulled those strings are incredibly clever. The documents state Moshe provided a $2.5 million loan to the clinic, which was secured against the clinic's own receivables.
Which is brilliant, maliciously speaking.
Right. If you hold the debt and control the receivables, you basically control the operation. And Dr. Shapiro, the actual physician, was allegedly paid a $400,000 salary just to act as a nominal medical director.
Yeah, he just provided the legal medical face for an operation that was entirely run by business interests.
Okay, hold on. Let me push back on this for a second. Let me play devil's advocate.
Sure.
If a patient actually goes into a room, gets an MRI, or lies on a table and gets adjusted by a real licensed chiropractor, why does the insurance company even care if a businessman is secretly managing the clinic's finances? The physician treatment is still happening, right?
That is the exact defense often used in these cases, but it totally ignores why the corporate practice of medicine laws exist in the first place. When businessmen control the patient flow and mandate heavy kickbacks, the entire concept of medical necessity basically evaporates.
So the priority just shifts entirely.
Absolutely. A doctor is bound by ethical and professional standards to only prescribe the treatment you genuinely need to heal.
Right.
A businessman running a referral ring where he is paying $50,000 a month just for access to patients has a massive overhead to cover.
Yeah, he has to make that money back.
Exactly. He is heavily incentivized to ensure every single patient undergoes as many high-billing procedures as possible just to guarantee a return on his investment.
Yeah.
In that environment, the patient is no longer a human being requiring care. They are merely a revenue stream to be optimized.
Okay, yeah, that makes perfect sense. The profit motive completely overwrites the medical motive. So State Farm's analysts eventually catch on to this.
It took a while, but yeah.
They look at the data, they see the identical treatment protocols across thousands of patients, they spot the bizarre rent structures, and they do what any insurance company would do. They stop paying the bills.
Naturally.
But the defendants don't just pack up and run away. They actually go on the offensive. And here's where we get to the weaponization of the legal system.
Yeah, this is the pivot that elevates this from a standard fraud case into a massive legal paradox. When State Farm denied the claims, the defendants began filing legal actions to force payment.
Which you'd expect.
But they didn't file one giant lawsuit challenging the denials. As of December 2021, the defendants had filed over 2,450 arbitrations and approximately 480 state court lawsuits seeking those unpaid bills.
That's almost 3,000 separate legal actions.
Yeah.
And the crucial detail from the source is how heavily they fragmented these claims. They actively avoided grouping them together. Every single arbitration is for a single medical bill, for a single date of service, for a single patient.
It's death by 1,000 cuts.
They even allegedly changed the names of the corporate providers operating at each address, just to further obscure any recognizable pattern. I mean, imagine if you noticed a massive string of fraudulent charges on your credit card.
Right.
But instead of letting you dispute the whole stolen card with one phone call, the bank forced you to travel to 3,000 different courthouses in front of 3,000 different judges to argue over every individual $3 cup of coffee.
You'd go insane.
You would never be able to prove there was a thief. You'd just look like a crazy person arguing over coffee.
And that fragmentation is a brilliant and incredibly dangerous strategy. State Farm argued to the federal court that this decentralized attack causes irreparable harm due to a legal concept called preclusive effect, which is often referred to as res judicata.
Okay, so translate res judicata for us.
Yeah.
What does that actually mean for the insurance company?
Think of it as a legal lock. If these single, isolated cases proceed, an independent arbitrator is going to look at just one file in a complete vacuum. They see a bill for a $200 neck brace for a car crash victim.
Seems reasonable.
Exactly. In isolation, that seems perfectly medically necessary. So the arbitrator orders State Farm to pay it. But because the No-Fault Act makes arbitration binding, that decision locks into place as a legal fact.
Oh, I see.
State Farm can't later argue that the neck brace was part of a massive fraud because a judge already ruled the neck brace was legitimate. If the fraudsters win thousands of these tiny, isolated cases, they are essentially forcing the insurance company to finance the ongoing criminal enterprise using court-ordered payouts.
Man, the very legal system designed to resolve disputes is being used as a shield to hide the fraud and a sword to extract the money.
It's incredibly twisted.
So State Farm realizes they are going to bleed to death from 3,000 paper cuts. They go to a federal judge and say, please, you have to freeze all 3,000 of these scattered state and arbitration cases so we can prove this massive RICO controversy all at once in federal court.
Right.
But they immediately crash into two massive historic federal laws that are literally designed to stop federal judges from doing exactly that.
The federal paradox. This is the crux of the appeals court decision. State Farm had to overcome two massive hurdles: the Federal Arbitration Act, or FAA, and the Anti-Injunction Act, the AIA. Let's look at the FAA first, which protected those 2,450 arbitrations.
Okay.
Enacted in 1925, the FAA's whole purpose was to make arbitration agreements just as valid and enforceable as any other contract. In the eyes of federal law, arbitration is generally sacred. If you agree to handle disputes privately, you can't come crying to a federal judge later just because it got complicated.
And the district court initially tried to help State Farm, right?
Yeah.
They said, well, New York law mandates that no-fault policies include an option to arbitrate, so State Farm didn't really privately negotiate this. Thus, the FAA doesn't apply.
They tried.
But the appeals court corrected them. They said, no, State Farm chose to sell insurance in New York. They consented to the local rules, so these are absolutely valid, binding arbitration agreements.
This is a huge blow.
But, and here's the twist, the appeals court still stocked the arbitrations.
Yeah.
Yes. They halted them by relying on a rare, judge-made exception called the effective vindication doctrine. The Supreme Court has established a rule. You cannot use an arbitration agreement to prospectively waive a party's right to pursue federal statutory remedies.
Okay, so if arbitration is supposed to be like a fast pass lane at a theme park, the Supreme Court is basically saying you can't use the fast pass lane if it leads directly into a brick wall that kills your basic federal rights.
Precisely. Arbitration is a tool for streamlining disputes, not a tool for granting immunity. The court determined that forcing State Farm to fight 2,450 mini-battles would completely choke off their ability to ever prove their sprawling federal RICO case.
Because of the res judicata thing.
Exactly. The arbitrations themselves were the weapon being used to dismantle State Farm's federal rights. Therefore, the federal court had the authority to pause them.
Okay, so that handles the arbitrations. But what about the 480 actual lawsuits sitting in New York state courts? This is where State Farm hits the Anti-Injunction Act, which is an incredibly old law. It dates back to 1793.
Older than most of the government. Yeah.
Right. And its core message is about maintaining boundaries and respecting state courts. A federal court cannot just reach down and hit the pause button on state litigation whenever it feels like it.
And the Anti-Injunction Act has only 3 very narrow, very strict exceptions. State Farm relied on the first one, which says federal courts can enjoin state proceedings if it is expressly authorized by act of Congress.
Okay.
The legal test for whether a law meets this exception comes from a Supreme Court case called Mitchum. The Mitchum test asks a simple question. Did Congress create a unique federal right that would be entirely frustrated if federal courts couldn't stop state proceedings?
And the Supreme Court elaborated on exactly how to apply that test in a major antitrust case called Vendo.
Right. In the Vendo case, the controlling opinion laid out a very narrow path for federal intervention. It established that if pending state court proceedings are themselves part of a pattern of baseless, repetitive claims being used to violate a federal law, then a federal court can step in.
But wait, zooming out for a second, isn't it a massive overreach for one federal appeals court to just silence hundreds of state judges?
Yeah.
Doesn't that break the whole dual court system we have in America? We have state courts handling state matters for a reason. Why does a federal court get to act like a king and just shut down the state's operations?
It is a massive, highly unusual intervention for sure. The appeals court had to look deeply into the history of the civil ICO statute, the Racketeer Influenced and Corrupt Organizations Act, to justify it.
Okay.
They pointed back to a 1967 report by the Katzenbach Commission, which was studying organized crime. When Congress created civil RICO, they modeled it heavily on antitrust laws. The entire purpose of RICO was to give private victims a bazooka to fight organized crime that had infiltrated legitimate businesses.
And the legislative history actually showed Congress was worried that state courts might be too fragmented or ineffective or even corrupted to handle mob-level racketeering.
Yes. The appeals court determined that when a pattern of baseless, repetitive claims in state courts is itself the illegal weapon being used to monetize a fraud, those state courts essentially become unwitting pawns in the criminal enterprise.
That is wild.
If the fraudsters are using the machinery of the state court system to fund their racketeering, the only way to give the federal RACO statute its intended power is for the federal court to step in and freeze the state cases.
It's like the federal court had to pull the emergency brake on the entire state legal apparatus just to stop the train from going off the cliff.
Yeah.
The lawsuits weren't just the aftermath of the crime, they were the engine powering it.
They recognized that the fragmented litigation was a central component of the racketeering enterprise. If you don't stop the lawsuits, you don't stop the fraud.
Man, what an incredible journey this deep dive has been. We started off looking at shady rent payments and subleases in a random clinic in Brooklyn. And we ended up at the intersection of the Federal Arbitration Act, a boundary law from 1793, and the foundational history of organized crime statutes.
It really escalates.
It does, and the whole thing really reveals how modern fraudsters exploit the incredibly fragmented nature of our healthcare and legal systems. They hide massive, multi-million-dollar conspiracies right out in the open, just buried within thousands of perfectly normal-looking everyday transactions.
It exposes a profound vulnerability in how our society operates, honestly. These systems, whether it's medical billing or private arbitration, they are built on trust and the assumption of good faith. When that good faith is systematically exploited by bad actors who understand the rules better than the people who wrote them, the traditional, slow-moving mechanisms of justice just really struggle to keep up.
Which leaves me with a final thought for you to ponder. The no-fault system's simplified arbitration rules were explicitly created to help the little guy. The whole point was to keep regular people out of backlogged courts, help them avoid hiring expensive lawyers, and give victims paid fast so they could heal.
Such a good intention.
But did simplifying those rules inevitably make the system easier to hack? When we design laws to be incredibly fast and frictionless for everyday citizens, are we inadvertently building the perfect automated cash register for organized crime?
It is the ultimate tension between efficiency and security. Building a fast pass lane is great for the public, but this case shows exactly what happens when an organized enterprise figures out how to monopolize that lane for themselves.
It really does. Thank you for joining us on this deep dive. Keep questioning the systems around you, and we'll see you next time.